I'm here with Graham Wolloff, our friendly IP practitioner that I've used at GreenStones for nearly 20 years now. And today, Graham's going to share his top 10 business ideas that you will not find in a textbooks. Before we get to Graham, please remember to like this video, comment below if you have any questions, and make sure you hit that subscribe button in order to be notified when we publish further videos going forward. Let's get started. Good morning to everybody that's arrived bang on time this morning at 9:30. I'm here with Graham this morning, who's going to share 10 business recovery ideas that you won't find in a textbook. So we'll just give it 30 seconds or so in order to let everybody come in. The technology sometimes takes a little bit of catching up with us, and to behind the scenes this morning, it's had a little bit of a catching up with Graham and I as well. So fingers crossed today it all works and all flows through. So we'll just give it 30 seconds or so, as I said, in order to let everybody wade in, and then we'll kick off. As always, it's your opportunity this morning to ask any questions that you've got of Graham, or indeed me, if you think I might be able to answer them. So as always, I say, just pop them in the Q&A box. I'll keep an eye on that over here or in the chat box, and I will gladly interrupt Graham and ask those questions as we go along. And I've also got some pre-registered questions, which are up over here on our screen, that we'll be asking Graham once we've gone through the 10 business recovery ideas, if we've not already covered them off. So please, as I say, feel free to ask any questions in the chat box or the Q&A box as we go along. Now it's 9:31, so without further ado, I am going to hand you over to Graham Wolloff, who will be sharing his 10 business recovery ideas. Go, Graham.
Morning, everyone. Thanks for the intro, Simon.
Morning.
Just before we get started on those 10 ideas, I just wanted to give you some brief background of the history and relationship between Simon and I. We're both based in Peterborough, and I opened up my office there back in 1999, having just left that monster known as PricewaterhouseCoopers. So I arrived in what was to me the sleepy rural town of Peterborough, and set out to market my services to the local accountants. And by and large, that was successful, except when I was trying to deal with Simon at GreenStones. I was constantly blanked. They refused to meet with me, refused to talk to me, and basically wouldn't take my calls. So I ended up writing in and saying, you've made it very clear you don't want to talk to me, and therefore I'm going away, and I'll never see you again. But a little while later, Simon decided to pick up the phone and talk to me, and I think we've had a fairly fruitful relationship since then. Would you agree, Simon?
Yeah, very much so. I think if I remember correctly, I produced a newsletter. It was our first hard copy newsletter, and you wrote me a nice letter saying how wonderful that newsletter was. So you flattered me in order to get through the door. And the only time we've fallen out since was when you beat me at pool. But anyway, definitely from my relationship point of view, I cannot remember how many times I've lost count of how many times I've picked Graham's brain on a situation that I've got with a customer, and Graham has delivered. And the best bit about the relationship, without going into all the ins and outs of it, Graham, is Graham's ability to take a commercial view on a situation that we've got and advise in the best interest of the customer, rather than in necessarily Graham and EWS's best interest. So yeah, fantastic relationship, and I'm delighted to have you here, Graham, to share this morning. So what's the first one?
Okay, so these are tips that I've picked up over the last 21 years that I've been, if you like, an independent advisor looking after directors and accountants' clients, because all the years prior to that, I was really on the dark side, if you like, acting for creditors or the court, and not paying any attention to the director's best interests. But over the last 20 odd years, we're looking at tips that I've picked up of ways which directors could do things differently to try to get some benefit particularly if there were a formal insolvency, which they had not obviously anticipated. And the first one is to do with something called Section 216 of the Insolvency Act. And that's the provision which says that if a company goes into liquidation, then the person who's been a director at that time or in the previous 12 months cannot reuse the same name or a similar name, what's known as the Phoenixism. So that ban on reusing a similar name lasts for 5 years. So the tip on this one really is to think about whether it's worthwhile to have a second company running. Because if you have two companies running and one is, well, they're both using a similar name, then if one of them goes into liquidation, providing that other company has already been actively trading for 12 months, then it has earned the right to use that name, and therefore the director is not banned from reusing that similar name. So I appreciate that there is a cost in having a second company running, and it cannot be a dormant company, but I've seen situations where the only alternatives to that are costly, expensive, or difficult because the trading name is so well established. So tip number one would be to consider having a second company that has that similar name.
So a couple of questions on that then, Graham. So basically, if I liquidate a company or a customer liquidates a company, then if they can't reuse the name unless they've been trading with a similar name for 12 months before the liquidation. That was the crux of it. Okay.
Yeah.
Who decides whether a name is similar or not? Is it a company's house? Is it the Insolvency Service? Is it the director himself? Do they try and get away with it? If that makes, how do they get caught? I suppose is the $64 million question.
Okay, it's a good question. The answer is you can try and get away with it, and you'll only get caught if someone wants to make an issue of it. So there's two ways it made an issue of, either because some other creditor of the company wants to get revenge and raises the issue, or perhaps the second company goes into an insolvency itself. And if that happens and the director has been acting in breach on that second company, then the problem is that the director is then jointly and severally personally liable for the debts of the second company. That is the debts that were created whilst he was in breach of Section 216. But the other sting in the tail is if it becomes to the attention of the officials, i.e. the next liquidator or the government, then it is a criminal offence as well. So the director is not only facing joint and several personal liability for the debts of the company where he acted in breach, but also criminal action, the criminal record.
Blimey. So the risk is all with the director to take. So they come up with a name, and it's their risk as to how close that name is.
Yes, and you asked who decides what is close.
Yeah.
What is a similar name? And the answer to that is, well, if it gets to court, it's the judge.
Okay.
But in most cases, it's blindingly obvious.
Yeah. Well, yeah. I can imagine customers being quite creative with how they come up with the names. Yeah. So it's basically they come up with a name, they accept the risk, and then it's a creditor that effectively will report them more likely than not. Is that a safe thing to say?
Yes, there are actually now people out there who go round looking for these situations.
Oh, okay.
And they acquire the debts from affected creditors in order to sue the directors. So they are what you might call vultures, circling over the corpse and looking to have a go. So I recently was asked by a solicitor in London to advise one of their clients who was being sued for £800,000 by somebody who had acquired one of these debts for a very nominal sum, £100 or something. But the director had got a £1.5 million property down south and was facing losing it because he was in breach of the reuse of similar name.
So very, very high risk then. So I've got a question from Elliot. Elliot says, at what point does the 12 months looking back start? So is it 12 months from the appointment of the liquidator, 12 months from the liquidation of the so it's 12 months from the
the same thing. The liquidation date, you go back 12 months from the liquidation date.
And that's effectively the date of the appointment of the liquidator in my accountancy language. Brilliant, thank you.
And that could be a voluntary liquidation or a compulsory liquidation.
Okay, brilliant, thank you. So
but not administration or voluntary arrangement if you come across those terms. It's only liquidation.
Only on the liquidation. So they've got to have had the company, if they want a similar name, they've got to have had the company trading for at least 12 months from before the date of appointment of the liquidator.
Yes. Now that is the first tip.
Brilliant, thank you.
The second tip is related to that, because the first tip was based on something you can actively do before any insolvency comes along. The second tip relates to what you can do if an insolvency has come along. So your first get out was to have the company trading for 12 months, and your second and third get outs are then, if you've had a liquidation and you want to reuse a similar name, then you could apply to court and just hope that the judge is looking kindly upon you and grants permission. However, you need a lawyer really to get involved with that and make the application to court. So it's not a cheap route, and it's not clear and not certain that you'll get permission. So then the most common way of getting around this section 216 is to buy the name, the rights to the name, from the liquidator. And that's what commonly happens. I think, Simon, you may have seen that on occasions anyway. But in order to do that, the director has to set up someone has to have a new company. That new company needs to buy all or substantially the whole of the assets of the company in liquidation. So if you've liquidated a company and you've got lots of assets in the company, it's going to cost the new company a lot of money to buy all of those assets and buy the rights to the name. So that's the first hurdle to get over. The second hurdle to get over is that you have to publicize what's going on. So the director who wishes to operate that second company with a similar name has to write to all of the creditors of the first company, giving them a formal notice saying, by the way, I intend to become a director of this second company. And at the same time, you have to publicize that in the London Gazette, because that's official notice to all the world. So you can't keep it quiet and hide behind things. You've got to be upfront and out there. And I use the phrase that the director intends to become a director of the new company. So therefore, you can't use that get out if you're already the director of the company with a similar name. So if a director is facing insolvency, it isn't permissible just to start a new company with a similar name, which won't have traded for 12 months already, and then say, well, it was started before liquidation, so I'm all right. It's not, because you can't use that get out if you're already a director of the second company.
All right, blimey. So if you've got a second company, you need to make sure that you're not a director of it before you buy the name. So
yes.
Yeah. Okay.
So, typically, the directors that I'm talking to about this, they will get their spouse or another relative to be the director of a successor or Phoenix company, and then I will deal with the spouse to arrange for the sale of the assets to the Phoenix company, and then the director who's got the ban on reusing the name will go through the process of giving the notice in the Gazette and to all the creditors, so they become able to use that similar name.
So another subsequent question then, Graham. Who values that name? So I've got ABC Limited. I've got another company called ABCD Limited that I'm not a director of.
Yeah.
ABC goes into liquidation, and then I rock up and say, "Well, I really want the name ABC, Graham. I'll give you a tenner for it." Is that does it turn up in a brown paper envelope, or how do you work out what the valuation is?
Certainly, there's no brown paper envelopes involved, but it is the risk of the insolvency practitioner to come up with a figure which it doesn't get criticised for. So it very much depends on the circumstances of the client company, because if they've got a unique name that is very well known, then the value will be greater than a name which can only really be used by that director. So many companies actually bear the director's own name, and they want to reuse their own name. And so in law, they can't. So if it's just Williams Builders and you want to be Williams Builders 2020 Limited, the £10 will probably do it, because the insolvency practitioner is probably happy to say, well, what real value did that have? But there are other cases which I'm not going to name, where it's something which is known on social media, known on Google searches, and it's got a much greater value.
Yeah, because I suppose the goodwill that you're paying for, the goodwill that's attached to the name, even if you're not buying the customer list, technically buying the customer list and the telephone numbers and all the rest of it.
Yeah, and now depending how you structure the deal, you might purchase goodwill separately from the right to use the name. So you might only ascribe £10 to the right to use the name, but if the whole deal makes sense, sometimes the buying company will be taking advice from its accountant on how to apportion the sale consideration or purchase consideration. So it's the insolvency practitioner to satisfy the creditors that the IP, as it's known, I'll use the term IP for insolvency practitioner, the IP is taking a personal risk in doing it. So it depends on what the IP feels.
Okay, brilliant, thank you. I'm mildly conscious of the time, because we've done 2, I think, in 20 minutes, so we've got 8 more to go. Right. And we've also got some questions arriving as well, Graham. So
okay, the next one relates to that, really, because we talked about making sure that you've not got too much asset based in the company. So intellectual property rights is another asset where often when directors get to insolvency, they think, damn, I've spent all this money on this intellectual property, developing these products or ideas, and now it's in the company and I've got to buy it back from the liquidator. So the other idea was to say, if you have a second company, consider making that the home of the IPR rights and licensing them to the operating company, the one that has ended up in insolvency, because that way the liquidator is not the owner of those rights and is not going to be selling them to you. And it means that were there IPR rights in the company and you were looking to avoid the ban on reusing the name, you'd have to buy the whole thing again. So the second company has a use in A, getting around 216, and B, potentially being the home of the IPR, or in fact, any significant assets which it may want to lease or license or rent to the operating company.
Yeah, so we've got a number of companies that have the building in the holding company, and then the trading company underneath.
Yeah.
But this idea is basically that the intellectual property rights, they sit in the holding company as well.
Yeah.
And then they're licensed to the trading company. So if the trading company goes down for whatever reason, then the IP is protected in the holding company.
Correct.
Is that right? And do you have a feel? It's not something that I've ever dealt with before. Do you have a feel about how much is it? No doubt it's a solicitor conversation to create that agreement, is it, or is it a rock up on Simply Docs and download it for 35 quid? Is there a cost?
Most of the ones that I see are very much a DIY.
Okay.
Yeah. But you never tell a director not to go and take legal
advice. Yeah, of course. Yeah, yeah, that's their risk. So
yeah.
Okay, brilliant. Thank you.
Okay, moving on then. I know that there are many people going to be asking about directors' loan accounts, DLAs, and this is a topic which I have talked about endlessly to some of Simon's colleagues, because, as you all know, it's a common tactic for extracting monies from businesses. But then when you get an insolvency, there is still a director's loan account shown as outstanding. So the first tip really is, whilst you might recommend it to your clients, I would only recommend it where you are confident that the client is capable of monitoring things and taking action if there is a problem. So doing it right avoids a nasty surprise. I lost count the number of times that directors say to me, yes, but that's my pay. There's no way that you can ask me for that money back. And I have to say to them, well, I'm sorry, but we can. I know there are plenty of questions going to come on that one, so I don't want to go into too much detail at this point. But if, Simon, you want to ask a first question, then it's up to you.
Yeah, no, there's lots of questions on overdrawn director's loan account and the PAYE implications of processing payroll and things like that. So if we cover all those off at the end, then that'll tease the people watching and keep them perhaps a little bit things. But the fundamental part of that, and I don't imagine that you're seeing these yet, but there is within the accountancy profession, there's lots of conversations about people that have had bounce back loans in particular, and they've used those to live off personally on the basis that the loan was income. So they've not been generating income, and they've used the loan to live via their director's loan account. So in the not too distant future, if those companies don't recover and make the profit, then I think there might be an interesting conversation to be had about how those bounce back loans, how they've effectively made themselves personally liable for a bounce back loan where they didn't have any personal liability when they took it out. And I think there might, in the not too distant future, be some interesting conversations about who is liable for which aspect of that advice. But anyway, we will get to that before we disappear today. So
okay, all right. So the next tip was in terms of the opposite situation where directors are actually supporting the company by providing funding. So it's very sad when you see somebody who has thrown their life savings into a company which wasn't viable, and it's all gone. So if someone is thinking they're going to need to support their company, think about if there are any assets on the balance sheet, can we effectively exchange the asset for the cash that's being lent by the director, so that the director has got the asset away and out of the company, and is able to then use it to protect their own value or their own business in future, and to restart the business if they need to do so. I appreciate it reduces the balance sheet as the cash is used, but I still think it's worth thinking about purchasing assets. So I had a classic case where the company was recycling tyres, and it had one machine which could do that, and the director came to me and said, well, I need to put £60,000 in, but I can't afford to lose it. So I said to him, well, go and get that machine valued, find out what it's worth, and put your money in and actually buy the machine. A year or so later, he came back to me and said, didn't work out, we're going bust. But by that stage, he owned the machine. So he was much better off from a personal perspective. The next one's on the same theme about circulating cash. This came as a bit of a shock to me when I first came across it, but if you've got a director who is supporting the company and he puts, let's say, £30,000 in, and then the company is able to repay it, but then they've got a problem and he puts the £30,000 back in again, and that goes on and on and on, and money is circulating around, at the point of liquidation, if that director has been taking the money back, then the liquidator's claim against him is not for £30,000. This is effectively for the total of the repayments. And when I first came across that, and the lawyers were telling me that was the claim, I couldn't believe it either. But the situation effectively was that this director had put the same £30,000 in 12 times going round. And then when we produced our claims against that director, that there's other things going on. But in terms of the money that he'd taken out of the company in preference to other creditors, the value of that claim was 12 times 30,000. And I know that sounds wrong. I know that it sounds incredible, but it's happened more than once. You know, different firms of lawyers and barristers have confirmed that is the way that the claim is formulated. So try to avoid circulating cash around in that way.
So basically, if they stuck 30 grand in order to pay the VAT bill at the end of the quarter, and then the end of the first month they'd got the money so they could take it back out again, and then at the end of the quarter they needed the money back in to pay the VAT bill, and they cycled that cash, then they are effectively paying themselves in preference to the creditors, and the insolvency practitioner or the insolvency service can then come and take all of that money back in order to pay the creditors that they've already.
So the chap may have a house plus £30,000, and he could end up losing the house because you've got 12 times 30,000 as the value of the claim. The second tip, if you like, is also about support funding, because many directors have an immediate cash need for the company and put the money in, and they become an unsecured creditor. To give credit to some directors, when they get to the point of insolvency, a lot of them say to me, "Oh, yes, I'm an unsecured creditor, but surely I don't have equal status with other creditors, like trade suppliers or tax bills." And I say, "Yes, you do. You are entitled to your share. You are a creditor." So many directors who've put money in actually don't feel they necessarily deserve to be of the same status as an unsecured creditor. But there is a way, a fairly obvious way, for the director who's putting money in not to be merely an unsecured creditor, ranking equally with the rest, and that's by taking a debenture over the company's assets at the time they put the money in. So that tends to be the directors who have gone to their lawyers in particular to say, well, how can I make myself a secured creditor rather than unsecured creditor? So that's always worth thinking about. But I appreciate that if the company already has a debenture to a bank, it could be difficult to then register a second debenture.
So just on that point then, Graham, you got any idea how much it costs to do a debenture? Is it a form at company's house? You got any idea?
I haven't got an idea, but it's a fairly standard document. So if you asked me to guess, I'd have said £2,000 or £3,000 from a local lawyer. So
cut and paste exercise and change the name. Then that's the Apologies to any lawyers that are watching.
The next one relates to intercompany debt. If the directors have got other companies and there are intercompany transactions going on, we often get situations where insolvency arises where those directors say to me, well, look, I never really intended that there be a debt owed by my other company, and surely it's not fair because the company going to liquidation owes money to a third company of mine. So surely I should be writing that off and setting it off rather than paying a substantial debt to the liquidator. Well, the answer to that one really is, well, it's your own fault. If you've not kept things tidy and not dealt with the set-offs up to the point of liquidation, then at liquidation, it's the liquidator's job to collect the debt that's due. So keep it tidy. The other situation that's related to that is where the company, instead of paying dividends up to its parent company, just makes a loan to the parent company, and the parent company then pays out to its shareholders. You get to the insolvency of the subsidiary company and find there's, let's say £500,000 owed by the parent, and the parent's got nothing. The problem there, of course, is the parent may have nothing, but the director is the one who has produced that situation and can therefore be accused of misfeasance and could end up being personally liable to repay that debt. So you may say to me, well, we want to make a loan rather than dividends, but be aware that can come back and bite just like a DLA can.
Yeah, especially if that holding company's got an asset in it or the intellectual property rights that the planning was done 2 years ago in order to protect. It kind of defeats the purpose. So yeah, okay, thank you.
Again, where a director is an unsecured creditor, you might, as I said earlier, say that they've got a claim that ranks equally with other creditors, but if the company wants to propose a voluntary arrangement in order to avoid a more serious formal insolvency, then you need to be aware that Revenue and Customs don't treat directors, debts owed to directors in the same way. If you're going to your creditors and saying, look, this hasn't worked out, I want a voluntary arrangement, will you vote in favour of it? HMRC will only do so if any debts due to directors or connected parties are actually postponed behind other creditors. That's their view, and it's the established way in which things are dealt with for voluntary arrangements.
So just to expand on what a voluntary arrangement is rather than a compulsory one, just in case anybody doesn't understand the difference.
So you probably can divide insolvency procedures between compulsory and voluntary. Compulsory is either where the court gets involved and makes an order to wind up a company, or it could be because a secured creditor is enforcing insolvency onto the company. The voluntary side of things is either where the directors come to an IP asking for a voluntary liquidation or possibly a voluntary arrangement. A voluntary arrangement is seen as being a softer, kinder, more inclusive approach where there's a business plan put together with the accountant. You go to creditors and say, look, will you chaps vote in favour of this? Because the alternative is a liquidation and you'll get less money out of it if there's a liquidation.
Brilliant. So the sort of, from an accountancy point of view, the crux of that is under a voluntary one, the creditors are much more likely to get paid than what they would do if it was a compulsory one. And there's another question that's just, is that right?
Yeah.
And then there's another question that just popped up. So if we get a CCJ, if the company, if a CCJ arrives that's been proven in court and they can't pay the CCJ, are they insolvent at that point? And one of the questions, in fact, what I'll do is I'll hold that, Graham. I'll let you finish off because one of the questions is at what point is a company insolvent? So we'll answer that as part of that process. So I'll let you finish off on your 10 tips.
Okay. So I've got 2 left. The next one is basically look before you leap and have a parachute. This again comes back to directors of small companies who've got absolute pride and faith in their business and can't see that things are perhaps going downhill. They often want to keep supporting the company. They're taking remortgages on their house, they're cashing in their pensions, they're going to their relatives, they're putting in their inheritances into it, and it's not a good idea, it's not a good investment. If they've put all of their available reserves or resources into that company without thinking about what might happen if, they may have no ability to buy back the assets from the liquidator that they need to carry on. So sometimes I think the job of the financial advisor or the professional advisor is to say to them, look, hold on, don't do this. You need to think about what your backup plan is. You need a parachute for if it all goes wrong.
Thank you. Excellent. And the last one?
The last one is do what Simon did 20 odd years ago. Find yourself an approachable insolvency practitioner that you can talk to and trust. Having come from PwC, I wouldn't suggest that you try to adopt that relationship with PwC. They're not quite that sort of firm. So generally speaking, find yourself a local practitioner that you can talk to. Whenever people say to me, you're an insolvency practitioner, is that what you wanted to do when you left school or college or university? I have to say, well, no, it was never in my plan. And I think I may have said to Simon many years ago, you might find that the insolvency practitioners are always in the kitchen at parties, but we can be useful. So find a good one and strike up a good relationship. It won't cost you a lot of money either.
Yeah, brilliant. And as I said at the beginning of the conversation, over the years, you've been invaluable with regards to the advice that you've given. So what I'll do is in the chat box, I will post Graham's contact details. So there's an email address and a website URL and a link for the LinkedIn profile. So if you want to say thank you to Graham, then please bang those, contact him on those bases. And if you've got any queries or anything that anybody would like to ask, you're happy to sort of have a preliminary conversation. Do they need to be local, Graham, or in this day and age when we've got Zoom and all the rest of it? Or
they don't need to be local. No, of course, I'm happy to talk to anybody from wherever. We're not the sort of firm who gets international clients, to be honest.
No.
But we have offices spread reasonably across the country. So I say local because sometimes you want to go out and meet the director and sit down and have a coffee, and it can come across better if you are saying, I'm sorry you have a problem, if you're looking them in the eyes.
But you're not just Peterborough based, are you? You've got offices all over the place.
No. Check the website, you'll see where we are, but there's a reasonable network of offices.
Excellent, thank you. And I've got your message, Phil, so thanks for that. Just we've got 20 minutes as a tops to fire through some questions, Graham. So I'm going to fire these at you. And as I said at the beginning of the conversation, if anybody's got any questions that they would like Graham to answer as we go through, please just pop them in the Q&A box and then I'll ask them. So the first one, let's go back to COVID and overdrawn directors' loan accounts and bounce back loans and the like. So Jim has asked, how will overdrawn directors' loan accounts / dividends be viewed where COVID has wiped out normal profits mid-year?
Well, exactly as they are now. There's no reason for a liquidator to make any concession for that. The whole point about the director's loan account method is that the person receiving the money is taking the risk. COVID was a risk that they wouldn't have foreseen, but the liquidator is there to get money back for the creditors. And very, very difficult to say to your creditors, look, I'm not going to pursue this because the poor chap got caught out by COVID. That's if you get into liquidation. But what I would say is that because it was not anticipated by anybody, you've got a much better chance of going to the creditors before a liquidation and putting the case that the poor chap's a victim rather than somebody who's ripped off the company and the creditors, and therefore you want to do a DIY voluntary arrangement under which the director is committing his time and energy to creating future profits to help pay the creditors rather than being obliged to repay his loan account. So I think people have got more sympathy at the moment because they know it's not someone's personal fault. But if you get into liquidation, I can't see a reason why the liquidator would not pursue the full amount as normal. Okay,
so if we said that, say for example, a company's got a 31st December year end, and they was trading in January and February, and at the end of February they declared a dividend out of profits, And then the world changed, and it got to the end of the March, and they hadn't got the money to declare a dividend because they'd made a loss for that month. What they should have done for that month is pay a salary to the director for the services that they had undertaken to look after the company. So there was no on that basis there would be no director's loan account in existence. Is that a fair comment?
You've got no loan account because there was no cash to make the payment.
Well, when the bounce back loan arrived in March, instead of that bounce back loan just being paid out as a dividend or via director's loan account, what it should have done is been processed as salary. So it was actually income of the director rather than a loan to the director in lieu of a dividend at the end of the year, for example.
Yeah. So if you're looking at a 1 month scenario, as you just set out, yes, there is a debt that's due. The amount is not great. The liquidator might not then take an action because there's an explanation of why it arose. But the most common situation, has occurred over months and months and months, or even years, where the debt has built up. I appreciate you're asking really in terms of the bounce back loan. When a director signs up for a bounce back loan, they make a statement to the effect the company is insolvent. So it's not insolvent, is solvent, and therefore should be able to repay that loan in due course. Of course, we've got no examples at the moment because things haven't really developed that far. But I suppose all accountants are sceptical about HMRC, at least in my experience. And there's many reports in the news about the abuse of bounce back loans by criminals. So I take some comfort on behalf of directors from the fact that HMRC may not be organised enough to follow through arguments that this director took the loan as a scam, effectively. Because the way I see it, the bounce back loans and the CBILS loans, they were made available because the government didn't want disasters on its hands. It wanted people to take the money and to try and survive. But I suppose it's a bit like speeding offences. The police are going to prosecute those who are doing 90 in a 50 zone rather than those who are doing 55. So if there's a fairly obvious abuse, then you're more likely to get hauled up for it. But I think there'll be many thousands of people who will not get hauled up because they can say, well, there was a reasonable chance. However, as you said, Simon, if they've just used that money to pay themselves, then they may have created a personal liability when they had none in terms of a PG on the loan.
Brilliant. Bought a hot tub or whatever it was that they went and acquired. Okay, so that's Phil's question was, what's your view on the BBEC bills replacing personal guaranteed debt following later by corporate debt failure? Well, that's effectively answered that. So they could create
thing, what's their intent there? It's a bit like a criminal offence. It's a crime if there was intent to commit a crime. So I'm sure there'll be thousands of failures following having one of those loans, and they may well have paid off debt that was personally guaranteed, but it's all about, was that their intent?
Yeah. Okay. I think Claire has asked, at what point do we refer a customer or a client to an IP?
Okay, cynically, but potentially when you feel your PI policy is under threat, but more commercially, when you feel that your client will appreciate the referral. Because if you're telling your client you need to go and see this insolvency practitioner and they're very reluctant, you might lose that relationship anyway. But if you develop that good relationship with an IP you can trust, you can dress it a bit differently and say, I've got this chap or lady that I'd like you to talk to because I think you'd benefit from it. So when that relates to the question you sort of raised earlier about when is a company insolvent, and under section 123 of the Insolvency Act, it is when a company cannot pay the debts that are due. So if you get a CCJ, you may not be insolvent, because it may be that you could pay the debts that are due and you just had a dispute, but you lost out on the CCJ process. But if the debt is due and you accept it's due, then you can become solvent again by agreeing with the creditor a different payment schedule. So if the debt was due 30th of September, on the 1st of October, you've not paid it, you're insolvent. But if you can agree a payment schedule, then it's now agreed for a different due date and you're no longer insolvent. But if you're talking about when was a company insolvent in terms of criticising or suing a director because they made things worse after insolvency, then you're really looking at a pattern of things which demonstrate that the company was insolvent. A number of CCJs or a winding up petition or some sort of solid evidence to say, well, that director must have known. There's no way you could be a director of the company and have got to that point without realising the company was unable to pay its debts as and when they're due. For the lawyers, the really interesting bit about when a company's insolvent is to go even further and consider the director's view of the future. So it may not be that the debt is actually due yet, but directors do have a duty to look forward and say, well, I can see that the company will become insolvent on a future date because of the situation that they're in. That's the really interesting grey area.
Okay, so
interesting for insolvency lawyers and professionals, that is.
Yeah, so the simple answer to that question is sooner rather than later.
Yeah.
To have a conversation. Does it trigger anything, Graham? So if I've got ABC Limited that that they're in difficulty and that they are concerned about their survival, if I ring you up and say, hello, Graham, I've got a customer that's they're in difficulty. I don't think they're insolvent. And we have a conversation, or you have a conversation with a customer. If in 6 months' time they go bust, is somebody going to come along and say, right, you spoke to Graham on the 1st of October, so you must have had an idea that you was going bust. You shouldn't have carried on for that next 3 months. You should have dealt with it back then. Does it create an implied liability or anything like that? Is there a fear of doing that?
There is a fear of doing that, but you've got to think about the facts of the case. So the fact that a director has spoken to their accountant or to an insolvency practitioner or somebody who's qualified as an insolvency practitioner who's got their business recovery hat on, that is just sound commercial sense. But it's the other facts that are the key facts. So if there was the string of CCJs, if there's a winding up petition, that's what the hard evidence is of the fact the director ought to have known the company was insolvent and should therefore be taking advice. Obviously I'm going to say this, but you could argue if the director has actually approached the accountant or approached the insolvency practitioner and got some advice, then it shows that they are being responsible and to an extent can protect themselves by saying, well, look, I took professional advice and based on that, this is what I did.
Thank you. I've got a question from Jeff. I'll surmise this question, Jeff, for you instead of reading it all out. So we've got a customer that is in financial difficulty, but they've not got any money in the bank. So how does Graham get paid, or how does the IP get paid? So I've got a company that's going bust. I've got no money other than pay you personally, which I don't really want to do I?
No.
How do you get paid? How does Graham get paid?
Okay. So companies that have got very little in the way of assets to pay costs, my advice to them is usually go to your accountant, do a strike-off dissolution and pay your £10 fee. However, it is worth having a look at what has led to that position, because a creditor could still force the company into compulsory liquidation by having it restored to the register and then winding it up. So if there are potential claims against the directors, for example, assets have been transferred at undervalue, I would always say, well, have a look at that, because if that director is going to face a claim against him, he might as well put some money into the pot to pay the liquidator's fees anyway and have it tidied up properly. So if a director has just taken £10,000 out of the company, or an asset worth £10,000, and paid nothing for it, and they're going to get a knock on the door and a demand of the money anyway, why not go through the liquidation process, get the asset valued on a breakup basis, pay for the asset, and get the company tidied up properly through liquidation.
So again, there are ways of making that work if you're having basically the conversation before it all happens, whereas once it's happened, then you're in.
Yeah. So
you're slightly restricted.
There's three options there. You either do the voluntary dissolution route, and it costs you the tenner, plus paying your accountant to do whatever they need to do, or you go to a lawyer and get them to apply to court for a winding up petition for the company, and then the government deals with it, and the government will be inundated with cases, so they're not going to be looking too deeply at some small cases. They won't have the resources to do so. Or you might find that there's a reason for actually doing the liquidation quickly through a voluntary process, and sometimes that's because there are employees who are out of pocket, and you want to get the company into liquidation in order that the Redundancy Payments Office can make payments to those employees. So you may have no immediate assets to pay the insolvency practitioner, but if the employees stand to gain, £50,000 from Redundancy Payments Office, it might be worth doing the liquidation, then getting the £50,000 of government money by agreeing with the IP that they'll pay the IP £5,000 of it or something, to have given them that opportunity.
So it basically is important to have the conversation before you start.
I will always say so. Yes.
Process. Brilliant. Thank you. Tiru's asked, what are the recent changes in insolvency legislation affecting the closure of limited companies with cash to distribute to directors?
Okay. So we're talking about solvent liquidations, I take it.
Yeah, solvent liquidation. Yeah. So I've been trading for a number of years. I've got 30 grand in the bank. What can I do?
Yeah. Well, obviously, talk to us. We are not experts on entrepreneurs relief, but my sort of rule of thumb, if there is less than £50,000 of surplus asset, you probably don't need a liquidator. If it's more than £50,000, you probably would benefit from having a liquidator, because the extra costs involved are more than offset by the tax gains,
tax savings
for the shareholders. So £50,000 is my rule of thumb.
Okay. And obviously, if anybody's got any situations like that, if they want to have a conversation with you about how you do that and the fees for doing it, you're more than happy to have that conversation. Thank you. Yeah. And then Rebecca has asked, that's the director's loan account, Rebecca. So we've done that one. If that's not covered, Rebecca, then please pop a subsequent question in the Q&A. How much does it cost? Nikolai's gone straight to the point, Graham. So how much would it cost to do a simple business with no assets apart from cash, to do a voluntary winding up? So Nikolai, give us a feel for it.
You're talking insolvent liquidation here.
A solvent liquidation. I think Nikolai's used the word insolvency, but it's a solvent liquidation of the cash in the company. So the situation that we just talked about,
right,
they've got 50 grand cash in the bank. Is it a 50 quid job, £1,000 job? What's the?
Yeah. Well, we make sure the accountant gets paid for doing their stuff, and we're keen for the accountants to deal with all the tax affairs, the PAY and the VAT, etc. But in terms of the actual time commitment that we're involved in, if it's a simple cash job, you've got to allow yourself a budget of 3,000.
Okay.
For doing that. Now, simple cash job, it could be 50,000. I've had one that's over 100 million, and the fee was the same, because it's not related to the figures on the declaration of solvency. It's the time that you spend on it.
It's the same amount of work, whether it's £1 million or
Yeah.
50 grand, basically. Okay.
Yeah.
Okay, thank you. So I'm just conscious we've got 4 minutes to go tops. I will just run down the question. I think we've answered all the questions, but if anybody's in the meeting that's got any subsequent questions or anything that they would like clarity on with Graham, then please just pop them in the Q&A box and we'll gladly answer them. Nikolai's we've done, Rebecca we did, Claire we on the repayment. What's the best way of recovery for a startup SME in the UK, considering the impact of the current pandemic? We've answered lots of stuff around that and making sure that we've got stuff in place. What point do we clear? And then just hear the ideas. So we've nailed all those questions, Graham, as well as your 10 top tips. So that's been a fantastic conversation. I'll just check the chat box. So there's nothing there and there's nothing in the Q&A. As I've said previously, and Mark's just reposted the contact details as well. So if anybody's got any questions or you lay in bed tonight or anything that you don't want to ask publicly, then please... So feel free to
if someone wants to email me a question, I'm happy to respond. If someone wants to see my my notes on my 10 tips, happy to send those out as well.
Brilliant. Well, what we'll do, Graham, is when we send out the recording of the video to everybody, we'll include those slides on the we'll include your contact details in there as well. So anybody that's watching the recording has got all of that for you. So there's no further questions. Anything else you'd like to add, Graham, before we disappear?
No, I think I've already covered it. But you do need to find an IP you can trust, I suppose. Is the
very much so.
message.
One of the best decisions I ever made, or one of the best decisions that GreenStones ever made from an IP perspective, was to I was going to say get into bed with you, but that's probably not the most appropriate to say on a Thursday morning. But anyway, lots of thank yous coming through. Elliot says thank you, Jeff says thank you, Gordon says thank you. So thank you very much, Graham. It's been an absolute delight to have you along this morning. VJ says thank you as well. Absolute delight to have you along this morning. Really thought-provoking ideas on how we can help our customers along, obviously, with an IP in order to make sure that they're protected and are looked after. So thank you very much for coming along, Graham. We'll do a virtual round of applause. And we'll do the obligatory wave goodbye. Cheers, Graham. Thank you. Bye-bye.
Cheers. Thank you.
Bye-bye. Bye-bye. What a session that was with Graham. And if you want to speak to Graham, then you will be able to find his contact details below this video. You will also find down the bottom here, if it's not there already, it will be very shortly, the next 2 videos that I recommend that you watch in order to help you inspire, challenge, and support you to run the best accountancy practice you would like to run. As always, please like this video. If you've got any comments or any questions, please pop those in the comments below and Graham and I will make sure they get answered. And also remember to subscribe to the channel so you get reminded when we publish the next video.